بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا ونبينا محمد وعلى آله وصحبه وسلم. In part 2 of our lesson on Multaqa al-Abhur, we are looking at what enters into a sale without mention and what requires explicit mention in order for it to enter into the sale. And this is an important issue because a lot of disputes arise, particularly in valuable matters related to this issue. So, for example, if someone purchases a house, the one purchasing the house would want as much as possible included in the transaction, whereas naturally, the one buying would want to keep as many things that that don't necessarily have to be in the sale to be included. Bismillahir Rahmanir Rahim. Alhamdulillah wa sallallahu ala Sayyidina Muhammad wa ala alihi wa ashabihi wa sallim tasliman kathira. So, what enters into a sale without mention and what does not enter without being explicitly mentioned. So, there are some underlying principles, and these could be summarized as being four. That what the name of the sale encompasses enters into the sale without mention. So I sell you this house, the house enters, right? For example, obviously. Secondly, what is permanently connected to the item being sold is it enters into it, or whose use is dependent, or if the use of the item being sold is dependent upon it, it enters. So permanently connected, for example, if you sell an orchard, the trees are permanently connected, so they enter. Or if you sell a house, but you don't include the keys, how can you use the house without the keys, right? So those are some examples. Then a governing thing is what customarily enters is considered to enter, because the principle is that al-ma'rufu urfan kal-mashruti shartan. That which is customarily known, it's as if contractually stipulated. So if in a particular place, if you sold a house, then all the flowers that were seen in the garden are included, then they're included, even though their plants are not considered to be permanently connected, as opposed to trees, for example. If someone sold an apartment, does the furniture enter? By default, it does not enter. Why? Because is it permanently is the furniture considered part of an apartment? No. Right? It's not connected. So the furniture does not enter because it's not a permanent fixture of the house. So when would it enter? It would enter if it customarily enters. But custom, right? And this is one of the aspects, that custom is not an arbitrary matter. Legal custom is that which is either the prevalent practice across all lands. This is called al-urf al-am, general custom. Or it could be specific to an area or an industry, and this is called al-urf al-khas. Right? The specific custom is called al-urf al-khas. Could also be in a particular industry. Right? There would be a difference between, for example, an apartment and a townhouse, for example. An apartment for professionals downtown. So it is sensitive. This is if it was not not explicitly mentioned. Good practice is in contracts, what does one do? One makes things clear and specific. And fourth is anything that is specified to be in the sale enters. Anything that is specified to be in the sale enters. And this is the best thing to do. Right? Because there's something that's clearly being sold, but there's other things that are not necessarily there. So you saw your friend's laptop. What else would relates to the laptop? The software on it, for example. But software has licenses, etc. So is the person giving away their use of the licenses, etc.? And that could enter, could not enter. Because let's say that Brother Asim is a designer and he had a whole bunch of good software. His designer friend saw his laptop, saw how fast it was, said, well, I thought all that software was in it. So it leads to dispute. So the same principles would apply. Is that software permanently part of the laptop? No, it's almost a bit like the furniture, right? So these principles would apply. What the name encompasses. If I sell you an open book pro, right? Leaving these meta corporations, an open book pro with these specifications. The software is not the computer itself. Could enter, could not. So then we look at each of these things. Is it permanently connected? Or the use dependent on it? What if someone sold a computer and deleted the operating system? Could you practically use a computer without the operating system? No. So that would not be considered to be something you could take out. And we'll be seeing specific examples in the text, but that's one example of a contemporary thing that leads to dispute. But anything customarily enters, and the fourth is what they specify, enters. So these are four principles, and you can see this in the opening discussion in both the commentaries. Imam al-Haskafi and Maulana Shaykh Zadar, rahimahumullah ta'ala. So you can find them there. Okay. So قال الإمام إبراهيم الحلبي رحمه الله ونفعنا به وبكم يدخل البناء والمفاتيح في بيع الدار بلا ذكر. So in the sale of a house, the building enters. And so do the keys. Now, what is a dar in classical Arabic? What's a dar? So a dar in classic Arabic originally is ما يدار حوله الحيطان. It's a walled property. Conceptually, it's a walled property. It's so-and-so's property. Now, the primary use of a property is to live on. So the building is the key thing in a property. It's a residential property, right? A dar would be a residential property. So the building would enter because of principle number one. What is principle number one? That the name encompasses. The name of the thing encompasses. The second example he gives is the keys. Because can you use the... I bought this, something I don't have the money to, but let's say that Brother Asim purchased a beautiful dar in old Damascus. But they refuse to give him the keys unless he pays $2,000 extra. That enters because of the principle, because one is permanently fixed to it. You could also say that a dar is custom. It's understood that the building would remain, but it's permanently fixed. The keys, because you cannot use the place without harm. The third principle is anything that enters urfan, customarily. So he says, rahmatullahi ta'ala alayhi. So these are mentioned, these enter even if not mentioned. وَكَذَا الشَّجَرْ فِي بَيْعِ الْأَرْضِ. Likewise, trees in the sale of land. Because it is permanently, that's considered permanently fixed. And by permanence there, they mean it's not there to be cut. That's what's meant by permanent. Right? اتصالها لا للقطع. Right? So permanently, in Arabic, they use اتصال قرار. It's there not to be cut, as opposed to that which is harvested, such as wheat, things like that. Okay. Then he says, rahimahullah ta'ala, that وَلَوْ أَطْلَقَ شِرَاءَ شَجَرَةٍ دَخَلَ مَكَانُهَا. If one purchases a tree without specification, then the place of the tree is included according to Imam Muhammad. And he says, وَهُوَ الْمُخْتَارِ, and that's the chosen position. خِلَافًا لِأَبِي يُوسُف. Right? So if he sells a tree, the land it's growing on is included. Because this is a tricky thing. And then the person would have to be given access, the right of accessing their tree. Here, of course, custom comes in. So if someone runs, and so for example, there are places you can go to purchase trees, but it's customarily known that these trees, what do they do with them? They will dig them up and either provide transportation for you, or you can come and take them and yourself plant them in your home. So that's where custom comes in. But the tree is permanently connected to the ground. The default is the position of Imam Muhammad, and that's one narration from the Imam. If you bought a tree, then the land it's on also belongs to you, and therefore you'd have to have access to the land. But Imam Abu Yusuf had disagreed with him on this, but they chose Muhammad's position. However, custom has an important role. Many places you have these places that sell, they sell flowers, but they also sell trees. And if it's custom, the principle of al-ma'ruf urfan kal-mashrut shartan. Okay, that's the chosen position. Khilafan li Abi Yusuf. And but what if it's not connected to the land permanently? He says, وَلَا يَدْخُلُ الزَّرْعُ فِي بَيْعِ الْأَرْضِ. That crops do not enter in the sale of property. Unless specified. Unless specified. So you purchased a property, a wheat farm at the beginning of the season. So the guy transported all the wheat crop. So item number 4, which would be unless specified. Best thing to do with all these things, particularly in sales of material significance, is number 1, it's sunnah to write down transactions, correct? Number 2, anything that could be differed upon reasonably should be specified. So write down anything of significance, anything that could be differed upon, should be written down, and also anything that would be unclear to the two parties, and anything that is rightfully yours shar'an, but people may not know about it. It's best to put it in the contract, and that's a separate matter. Right? So that's from the art of writing a good contract, are those matters that one should write down anything of significance in general. Number two, anything that could be differed upon, anything that is unclear, also anything that is rightfully yours, but the other person may not know about, so therefore dispute could arise. If the contracts are particularly important, it is good, particularly significant, it's good to also include the dispute resolution mechanism. So it's, for example, it's between Muslims, say we will resolve this according to this madhab. It's good to stipulate we would go to for dispute resolution, because if people are fighting, they're not going to, once fights arise, they're not going to agree on how to resolve the fight. Inna nafsa amaratun, not bil khair, right? Bisu, right? And when the nafs is stirred, su is stirred. And we should keep su asleep. Okay. وَلَا الثَّمَرْ فِي بَيْعِ الشَّجَرِ, nor do fruits in the sale of a tree. And thamar, okay, what does thamar refer to? Thamar is not necessarily the fruit in the English sense, but thamar refers to that which is produced by a tree or a plant. Right? The thamar of something is what it produces. And a shajar, right, is anything that has a trunk. So many types of what we would call shrubs, etc., would, if they're permanent, the classical Arabs would also refer to it as shajar. But you can read up on that in the now, what's the difference between zara? Crop is that which is harvested, and cut, that which remains. Like, there's certain types of plants that you cut the fruit, you don't cut the plant. If they have a clear stalk or clear like shrub that remains, that growth would be considered a shajar in classical Arabic. That's not necessarily, of course, modern usage. Okay. And usage is also varied through history, so one has to be awake when it comes to usage. Okay. So the fruits do not enter in the sale of a tree unless specified, right? Unless specified. So he says, إِلَّا بِاشْتِرَاطِهِ, unless specified. وَإِن ذُكِرَ الْحُقُوقَ وَالْمَرَافِقِ, even if one mentions associated rights and, surrounding matters, right? Rights and surrounding services, these encompass primarily two things, which is the drainage, right, and the access to the water. So this is the masil, where the water flows from, right? Because if it rains, okay, where's the water going to drain from? Because you bought a building on someone's plot of land. You need access to two things. The masil, where the water flows from, because they block your access to water. Where's the water from your building going to go? And number two, and that's a right. You don't own the land the water flows on. Number two, the shirb, which is the access point to the nearest water. In the old days, which would be like, you can't sell a building and say, but I will not give you access from your building to the water mains. And, if you have plumbing, obviously, those are the حقوق المرافق. In the old days, also access to be able to go to the stream, etc. Those are the حقوق المرافق. Because without that, one cannot benefit from the property. Even if those are mentioned, why? Because you can benefit from the tree without its fruit. You, there's already fruit on the tree. It belongs to the seller. Next year, trees are a long-term thing. The upcoming years, the fruits are yours. If you had wanted the fruits, you needed to have specified it in the contract. تماما. So, but then a tricky thing happens. ويقال للبائع إقلاعه واقطعها. Right? إقلاعه, إقلاعه, where does the ضمير go to? Right? This is لف ونشر مرتب. إقلاعه أي إقلاع الزرع. That, so someone sold land. So the buyer has the right to the land. There was wheat crop on it. Let's say I had a farm, I grew wheat. But I'm selling, I'm selling it. The buyer wants to build a house on it quickly. So I sold him the land. I say, excuse me, you have to wait 4 months until the wheat comes to harvest. Is that reasonable? No, because once the sale takes place, who owns the land? The buyer, the mushtari, owns the land. So he has full right of usage over it. Whom does the wheat belong to, the zara belong to? It was not mentioned in the contract. It belongs to the seller, right? The mushtari. So there's this wheat, and the seller cannot say, no, you have to leave it there until it, he cannot force it. If he does force it, that is considered ghasb, misappropriation of another's property. The property is now the buyer's. If he wanted it to be otherwise, he would have agreed to something different. Iqlahu, right? Harvest it, cut it. وقطعها أي وقطع الثمرة, right? And pluck the fruits. Pick the fruits, because the tree belongs to, if you sold the land, now the trees belong to the buyer. And let's say the buyer wants now, okay, those trees, he's going to move them somewhere else. He does whatever he wants with them, but the fruits belong to the seller. So you could take the fruits. You don't have the automatic right that they remain. Simple reason, I bought the property. I want to build my residential home. I don't have a house. Right? اقطعها وسلم المبيع, and deliver the property. Right? Because full delivery entails that the item now be possible to use without preventative. Right? So for example, in a different case, if I sold my sibha to Ayman. Ayman, I sell you the sibha for $50. She says, I agree. I said, okay, now it's yours. What's the problem? It's right there. Would a self-respecting Muslim woman try to grab the sibha from me? No. Right? So, تمام التسليم يقتضي رفع الموانع. Right? Full delivery entails that you remove anything preventing it. Which is obvious. But the reason this is mentioned, these things lead to dispute. Okay. So this is the basic issue. But there are things that do not enter. Right? وكذا لا يدخل حب بذر لم ينبت بعد. Likewise, the seeds that haven't sprouted don't enter into a sale. Right? Right? So some seeds had been planted, but they haven't grown yet. If the seller wants to be really, he wants them. Right? One example would be, I planted very precious, rare flowers. I have these seeds. I planted them. I was intending in my orchard that these very rare flowers. So I planted these seeds. But then Ayman came and said, Uncle Faraz, I'm a single mother. I need to build a house right here to take care of my elderly mother, etc., etc. Can I buy this property? Okay. So I sold it to her. But those seeds do not enter, even if they're seeds of a tree. They're rare Japanese bonsai trees that I just planted. Now, the trees, once they grow, are permanent, correct? Trees, once they've grown, are permanent. But the seeds are not permanent because you could simply remove them if you wish. And in some cases, like the example given, the reason would be obvious. It's not them necessarily being stingy. But he says, وَإِن نَبَتَ وَلَمْ تَصِرْ لَهُ قِيمَةٌ دَخَلْ. But if it has grown and it now has a material value, it enters. Right? وَقِيلَ لَا. And others said no. The first opinion is stronger when it comes to trees. That if it's started growing, it's grown enough that it now has material value, a tree or a permanent plant enters, even if it's not grown fully, because it has material value. But between the two opinions, what would count would be custom. The first is stronger because this is a sapling tree considered permanent once it has grown and it has some material value as a tree. Okay. And then he says, rahimahullah, وَمَنْ بَاعَ ثَمَرَةً بَدَى صَلَاحُهَا أَوْ لَمْ يَبْدُ صَحَّ. If one sells fruit, right, that has appeared, right? باع ثمرة بدا صلاحها أو لم يبدو. The condition is that it has appeared. If one sells fruit, that has appeared. Whether or not it is now become salih, right? It has now grown sufficiently so it is fit for use. Or it's not yet fit for use. Right? But the key is it has appeared. باع ثمرة ظاهرة, as Imam al-Haskafi says. If one sells fruit that has appeared, it is valid, as he'll tell us. يصح. Whether or not it is fit to use. And the criteria is as long as it has some value. Right? As long as it has some value. Even if it is as fodder. And if the ulama gave a practical opinion, right? That if one sells a whole bunch of trees, they have, so you're selling the fruit on these trees. Some of it has grown, some of it hasn't. You can take all of it, even if some of it has not yet got material value. You can seek And the things that haven't grown yet are considered tabi', secondary to what has grown, practically. And you can read the discussion. The earlier scholars were a lot more careful about this, but caution is not always practical for the general public. Okay, so that's if you sell the fruit on these, or you, okay, I want, someone really like these apples that I have. They want to buy all the apples on my trees. They can see the trees. They say, okay, I'll buy all these apples, but some of them haven't grown fully yet. You can take all of them, even though some of it is not technically sellable. It's considered tabi', and the principle is التابع لا يفرد بالحكم. التابع, there's the fun. It's as if the sale takes place on what's fit to sell. The other ones, the ones that haven't fully appeared yet, are considered tabi', like secondary. And the principle is التابع لا يفرد بالحكم. The ruling is not applied primarily on the details. And يغتفر في التوابع ما لا يغتفر في المتبوع. Things are excused in details that are not excused in the essential elements of a transaction. Yeah, so this is a scenario where, so you said, okay, I sell you all the apples on these trees, and I have a row of apple trees. Okay. But some of them, 20%, 30%, have not appeared yet. It would be valid as if you purchased the ones that have appeared, and the others are considered secondary. A corollary example to this, so this principle, like التابع لا يفرد بالحكم, that the secondary elements are not singularized for the ruling, and one forgives in details that which one does not forgive in the essentials of a sale. Can you buy shoes that are made from pigskin? No. If they're made from pigskin, but this is if the shoe itself is from pigskin, because it's najis al-ain. But what happens, and this is fiqh, right? So there's one sheikh, actually part of the Seekers Guidance faculty. He used to be really poor at one time. Poor guy. He was going and teaching classes wearing really bad shoes. And at the mahad he went to, they said, yeah, sheikh, please come with proper dress shoes. You're standing in front of a class. So he went and bought shoes. Then he was told, yeah, sheikh, this has got pigskin in it. So he went, threw them in the garbage, pious guy, and bought another pair. Same thing. Happened 3 times. Then he actually showed up to class wearing, I kid you not, wearing a plastic bag on top of his socks. I saw him before he went to his institute. I said, Sheikh, what are you doing? He said, because the 3rd or 4th pair of shoes that he got also had pigskin. But the pigskin was where? Very often pigskin is in at the heel, at the back of the shoe, and sometimes in the lining. But the main part of the shoe is what? Is the main shoe. So this is a matter, I sought fatwa from a number of leading ulama. This happened in 2000, the year 2000, maybe 2000, 2001. And the fatwa from many leading scholars, right, and this follows the principles of the Hanafi school, is that if the shoe is from permissible leather, which is any leather besides pigskin, and the heel or the back of the foot or the lining is of pigskin, then it is not haram to have. It's not even haram to sell. It's makruh to sell. So if you're a God-fearing person, you wouldn't sell it. But people work in shoe stores. Right when I was researching this issue, we were asked a question on Sunni Path that, I work in a shoe store. Some of the shoes have pigskin in the back, etc. In this manner, can I sell them? And it's not by default, it's not haram, it is makruh. Someone else asked, can I sell these kinds of shoes if I work at my parents' store? Yes. Now, if you take over the store, you could change what you sell, but a person may not have the luxury. Why? Because this is considered a tabi'. So if someone has a shoe like that, taqwa would be that one dispose of it, but you could sell it because it's not haram. That which is fully haram, you cannot sell. And that would take us out how you deal with it, but just to understand the principle that excuse in details is that which is not excused in the fundamentals of a contract. Okay. So this is the selling fruits, whether they've grown or not, is valid. وَيَقْطَعُهَا الْمُشْتَرِي لِلْحَالِ. And the duty of the buyer is that they cut the fruit immediately. Right? Because who owns the fruit? What's being sold? The fruit. So the fruit belongs to the buyer, correct? Who does the tree belong to? The seller. Now the seller may want to cut the tree because, let's say, or he wants to take the trees, plant them somewhere else, whatever. So the seller does not have the right for the fruits to remain on the tree. So no, please give me a month till all the fruits have ripened. Please, I want my trees, I want my land, leave me alone. Right? So he says that وإن شرط تركها أي وإن شرط المشتري تركها على الشجر ترك الثمرة على الشجر فسد أي فسد البيع. If the buyer makes it a condition in the contract that I'll buy these apples on your trees for $5,000 on condition that I can keep them on the tree for a month or till they ripen. This corrupts the contract. Why does it corrupt the contract? Okay, this is not the fatwa position, but the default is that one has clarity and clarity in contracts. Because when you put conditions that are not entailed by the contract, it increases the possibility of what? Of dispute. Right? Because if we put a condition, right? So I sell you, I buy these fruits that are on the tree. Okay, now the fruits belong to me. The tree belongs to, Ayman. She didn't pay attention to the fact that on condition that the fruit remain on the tree. The contract, you say, I buy these fruits from you. The fruits on these trees from you for, let's say, $5,000 on condition that I can keep them on your tree till they ripen. They could take longer to ripen. So it's as if it's a sale plus a borrowing of the trees. Or if there's a price included, it's as if it's a sale plus rental. As if I'm renting the trees to keep the fruit on them. But in these details are secondary elements, right? Ayman, who's selling it, she's selling the fruit because she wants the tree. So she made that the condition is weaker than the thing itself, so it could lead to dispute. And anything that could reasonably lead to dispute, what does it do? It corrupts the contract. That's the default. That's the default. That's why it has come in the prophetic tradition. Naha Rasulullah sallallahu alayhi wasallam an aqdain fi aqd. The Prophet sallallahu alayhi wasallam interdicted two contracts in one. A sale with a hire in it. It's better to divide it into two separate contracts. Do this first, then that. Okay. So that is the default, because we pursue the path of caution when it comes to having clarity. It says, وَلَوْ بَعْدَ تَنَاهِ عَظْمِهَا. This is even if the um, the azm here is the body of the fruit. The fruit has grown fully. Right? And we'll be looking at the conditions and contracts in a little bit. So we'll be unpacking that more fully there. But then he says something in passing that is of significance. He just says, khilafan li Muhammad, as opposed to Muhammad. Right? Khilafan li Muhammad. The fatwa position here is that of Imam Muhammad ibn al-Hasan. Imam Muhammad ibn al-Hasan said that, he says, وَكَذَا شِرَاءُ الزَّرْعِ. The same thing applies if you purchased some crop. You cannot stipulate that it remain on the ground. Now here, Imam Muhammad ibn al-Hasan, what did he say? Imam Muhammad ibn al-Hasan, rahimahullah ta'ala, allowed selling fruit, someone buying fruits that are on a tree and stipulating in the contract that they remain on the tree until they have ripened. Why? Because of urf. Because people do this customarily and it does not lead to dispute. Two criteria. People do this customarily and it does not lead to dispute. So in terms of the core principles of transactions, the position of Imam Abu Hanifa and Abu Yusuf, which is that we don't have composite contracts because it leads to dispute. And however, Imam Muhammad al-Hasan deemed it permissible. Imam Muhammad al-Hasan deemed it permissible because of custom. It is a customary practice and it does not lead to dispute. And this is the fatwa position. And you can read the discussion in Maulana al-Haskafi's commentary. Right? He says, لِلتَّعَارُفْ فَكَانَ شَرْطًا يَقْتَضِيهِ الْعَقْدِ. Because any condition in which it's not just detailing the sale itself, the basis is that it can lead to dispute, so it's not permitted. Right? But if this kind of condition is that is not just the detailing the contract, like what's allowed by default is, okay, I sell you this sibha and I describe it, all the different elements, what is it made of. Yeah, I can add as many details and the type of string and the number of beads and all this stuff. That's detailing the item of sale, that's fine. There's limited other things that you could specify, but adding other things on condition that this and this and this, the more conditions you add, the more it can lead to dispute. And we see this one of the harms of modern contracts, that they've been complicated so much that lawyers make lots of money from complicated contracts. If you ever dealt with anything significant like buying a house or investing in a company, etc., contracts have been made complicated, and there's an economic justice aspect to that as well. If a contract is complicated, which party is likely to have more power in the contract? The individual or the corporation? The corporation. The wealthy or the poor? Right? The wealthy. So this is a mafsada. So returning to simplicity in contracts without harm is an important shari'i consideration. And minimizing dispute as well. So there's many wisdoms in these prophetic teachings. But the ulama As the Prophet ﷺ said, تُحْدِثُونَ وَيُحْدَثُ لَكُمْ. You do new things and new rulings are applied for you. Of course, derived from the revealed rulings. So the fatwa position on that issue is Imam Muhammad al-Hasan, that you can, if you buy fruit that's on a tree for an agreed upon price and you stipulate that it remain there until it ripens, this is valid. Why? Because of custom. Oh, because of sound custom. It's custom that does not lead to dispute. Right? And then he says, rahimahullah ta'ala, that وَإِن تَرَكَهُ بِإِذْنِ الْبَائِعِ بِلَا اشْتِرَاطٍ. If one leaves, the fruit on the trees with the seller's permission, without condition, the increase in value is طاب له الزيادة. طاب للمشتري الزيادة. Right? So if the buyer leaves them on the tree with the seller's permission, without making that a contractual condition, then the increase in material value is halal for him or her. And the ziyada here is not the increase in size, the increase in value, because ripe fruit is worth more than unripe fruit. وَإِن بِغَيْرِ إِذْنِهِ تصدق بما زاد في ذاتها. Right? من حيث القيمة. Right? But let's say that Ayman sold me the fruits on the trees. I said, but please, Brother Faraz, remove the fruits, because some people are going to come to take these trees. And she was traveling. She was going on Umrah. Pious lady, Ayman. So what happens? Ayman goes, tawakkal ala Allah. I kept the fruit on the thing. I live next door to them. So the guys come to transport the trees. Say, guys, but just leave the fruit on the trees for a few days. They come back again. They charge Ayman. That increase in value, is it halal for me? With it, the increase in value that occurred to the fruit, if we go from an unripened stage to a ripened stage, that is not halal for me. So what do I have to do? I have to give that amount in charity. Tasaddaqa, as sadaqah, I give it to the poor, because that was an increase, a material increase that is not rightfully mine. And how do we figure out what's the increase in value? We ask people who know about the value of such things, what is the increase in value between the state of it being without the unripe and then ripened? And likewise. Okay. You see, the Abdul Latif, could you make sure you just post the thing on the two channels? Alhamdulillah. There's some Christian evangelists there too. Jazakallah khair. Okay. So I hope this issue is clear. But these kinds of things are why Sayyidina Umar had banned people from entering the marketplace. And it's in the Muwatta, the rough wording is that the marketplace of Medina. He said, لا يدخل سوقنا من لم يتفقه في ديننا فإنه يقع في الربا شاء أم أبى. No one may enter our marketplace until they have learned our religion. And by dinina, he means the rulings related to transactions in our religion. For otherwise, they will fall into riba, whether they want to or not. And riba, every corrupt transaction takes the ruling of riba. So one aspect of it is to make our earnings halal, but also to make them tayyib. But number three, learning these rulings is integral to learning the ethics of our deen. And number two, the imperative in our deen to وَابْتَغُوا مِنْ فَضْلِ اللَّهِ, right? Seek from the bounty of Allah, as Allah has commanded us, right? In many verses in the Quran. But to do it according to this beautiful principled guidance of our deen. So he says, rahimahullah ta'ala, that وَإِنِ اسْتَأْجَرَ, sorry, what he says, وَإِنْ بَعْدَ مَا تَنَاهَتْ لَا يَتَصَدَّقْ بِشَيْءٍ. But if they've grown fully, if it's already ripe, if it's already fully grown, he just delayed picking it up, he does not have to give anything in charity. Okay. وإن استأجر الشجر وقت الإدراك بطلت الإجارة. If one rents the trees for the time, when when the fruit is ripening, that ijara is is fasid. And that is because this is not considered a customary hire. Number one. Number two, because the time period is unknown. Just leave it there until it has fully ripened. Ayman wants to pluck these trees, have them taken, and fruit takes their time to ripen. But again, if it is something that is customarily done, وَطَابَتْ لَهُ الزِّيَادَةِ, but one can keep the increase in value. وَإِنِ اسْتَأْجَرَ الْأَرْض لِتَرْكِ الزَّرْعِ فَسَدَتْ. And the same thing, if you rent the land to leave the crop on it, this is also corrupt. وَلَا تَطِيبُ لَهُ الزِّيَادَةِ. And the underlying reason is that this is not customarily done, and people normally sell land because they want to use it. They'll sell a tree, the fruit on a tree, because they want to do something with the tree. They want to chop it into firewood, they want to move it somewhere else. So this could lead to dispute. So because of these things, the assumption is it could lead to dispute, so it's corrupt. But if these things are customarily done, then, and does not lead to dispute, then it would be valid. So keep that in the note on all these matters. Then he says, rahimahullah ta'ala, on some derivative issues, ولو أثمر ثمرا آخر قبل القبض فسد البيع. But if the tree bears another set of fruits after that, after the purchase, the sale itself becomes corrupt. What's the scenario? I sold the fruit on my tree to Ayman. Now she has to, so before she takes her fruit, more fruit has started growing on it. The new fruit, who does it belong to? I'm the seller. So the fruit that was there at the time of sale, who does it belong to? To Ayman, to the buyer. But then before she takes that fruit, more fruit has grown, and a significant amount. The new fruit, who does it belong to? The owner of the trees. So it would lead to dispute what belongs to whom, right? So the fruit becomes undeliverable. So the sale would be corrupt there unless they are clear on who owns what, right? Or if it's easily distinguishable. ولو بعد القبض يشتركان. And if it grows after possession was taken, they are partners in it. والقول في قدر الحادث للمشتري. And how much is new fruit? The opinion there of the word of the purchaser is taken. Right? And in this, we look at custom. So that each person gets their right and there is no dispute. Okay. ولو باع ثمرة واستثنى منها أرطالا معلومة صح وقيل لا. If one buys some fruit and one makes an exception of a specific amount from it, this is valid. And that's a relied upon position. So, for example, if I sell, a whole barrel of dates, I say, I sell you this barrel of dates, Ayman, except for 2 kilos. The relied upon position is that this is permissible. Istithna, when made an exception of a specific amount of that, it is valid. And the underlying principle is, they say, majaza bay'uhu jaza istithna'uhu. Majaza bay'uhu jaza istithna'uhu. Anything permitted to sell, right? So it is specified, is permitted to make an exception from a transaction. And you can find this qaida in both the commentaries. Majaza bay'uhu jaza istithna'uhu. That's the relied upon position. And that's what most of the texts of the madhab follow. However, there was a concern. Let's say Ayman has never purchased dates before. Does she know what 2 kilos of dates look like? Necessarily? No. Right? So what could happen? So I sell you this, this tub of dates except for 2 kilos. Okay. So I take out 2 kilos, only some dates leave. Would she be satisfied with that? Only some dates are left. No, like it could affect the taradi in the sale. So some of the ulama, and some distinguished ulama amongst them, Al-Kamal ibn al-Humam in Fath al-Qadir, said the aqyas to the madhab of the Imam, of Imam Abu Hanifa, is that making selling a measure of dates, and accepting a certain amount from them would not be allowed. Why? Because it is reasonably conceivable that the other party would not know what's left. I sell you this, this container of rice except for 100 kilos. So that is the more precautionary opinion, but practically, this is something people would frequently do. Someone really liked, let's say, grain traders. Someone that is amazing. Yunnan Noir tea. So I want to buy the whole, the whole carton of it. Say, no, but I need 10 kilos. People do that all the time, especially in wholesale, etc. So the fatwa is it's permissible. Then if the person complains, but hardly anything is left, if you really wanted to know exactly how much was going to be left, if you're acting contrary to custom, then it's your duty to specify it. Right? It's your duty to specify it. Tamaman. Then he tells us, rahimahullah ta'ala, that وَيَجُوزُ بَيْعُ الْبُرِّ فِي سُنْبُلِهِ. It's permitted to sell wheat in its stalk. In bi'a بِغَيْرِ جِنْسِهِ. As long as you're not selling wheat in the stalk for wheat, that's taken out from its stalk. وَكَذَا الْبَاقِلَّاء فِي قِشْرِهَا. And likewise, beans in their pods. وَالْأَرُزْ وَالسِّمْسِمْ. And likewise, rice and simsim. What's simsim? What's it called? Sesame? Yeah, sesame seeds. Because each of these come in a covering. So can you see what you're buying? No. But it's very difficult. How else are you going to buy it? So this is something that, and usually if you buy a ton of wheat in its stalk, right? Like, so you buy the wheat, it's already there before it's harvested. People do this. Is it common for there to be no wheat in the wheat stalk? No. Is it common that in a, like in a ton of, if you get simsim in its shell, whatever, that there is no simsim inside? Unlikely. If there is enough that is missing, it would be considered a aib. It would be considered a blemish, and that would follow the fiqh of khiyarul aib, which is coming. So these things are all customarily sold like this. Normally, it would not lead to dispute. وَكَذَا اللَّوْزُ وَالْفُسْتُقُ. Likewise, almonds and pistachios. وَالْجَوْزُ فِي قِشْرِهَا الْأَوَّلِ. And a nut in its outer husk. Right? Because all, al-jawz, like walnuts. Why? Because all of these are customarily sold in this way, and it does not lead to dispute. If it turns out it was blemished, then it would be considered a'ib. Now, who pays for associated costs? وَأُجْرَةُ الْكَيْلِ وَعَدِّ الْمَبِيعِ وَوَزْنِهِ وَذَرْعِهِ عَلَى الْبَائِعِ. So, what if they differ? The associated costs of the sale, who has to cover those? So the cost of weighing the item of sale. Let's say we bought 10 tons of rice. There's some costs associated with weighing it to make sure the weight is correct, etc. And you want to do it objectively, so you bring in a company to weigh the item of sale. Who pays for the kayyal? The one who does the measure, or to count the item of sale. I buy 500,000 of these white pens from you. We want to make sure that the number is full. Who pays for that? Or to measure, or dhar'ihi, or the measure, it's on the seller. Because everything related to the complete delivery of the item, it is upon the seller. And anything by default. And anything that is from completion of the payment is upon the buyer. So he says, وَأُجْرَةُ نَقْدِ الثَّمَنِ وَوَزْنِهِ. Right? And the cost of checking the price. In the old days, you had to check if it's the actual, it's yani, Yani, is it is it real gold or silver, etc.? And counting the price or the transfer of the payment, etc., would be on the buyer. Right? Wazni, those you have to weigh like gold, etc. Is it actually this much gold? In our time, the cost would be on the seller. Um, okay, so the basic principle is the costs associated with the delivery of the item or completing the delivery item are on the seller. The costs related to the fulfilling the payment are on the buyer, the mushtari. Unless they agree to the contrary, or unless the urf is to the contrary. These things lead to dispute. Why? I sold you 500, like $5,000 worth of Islamic books. Who has to pay for the shipment? I live in Toronto. Ayman lives in Florida. Who has to pay for the books, for the shipment? If we already know where the two parties are, the default is I have to pay for the delivery. But these things should be specified, especially in our times when the two parties aren't necessarily physically in one place. Shipping costs are on whom? And it's more common than you think for disputes to arise. Someone's traveling from a country, they sold a whole bunch of their stuff, but the person they sell it to is not where the stuff is. So, but I understood this, I understood that. So those principles you mentioned, we should write down those things that we said in the beginning. Hopefully you're awake and taking notes. That applies to all these kinds of things. Because these laws are only applicable if the two people agree to apply them. Unfortunately. And when nafs is involved, truth becomes a mere murmur. Right? And then the last investigation, who delivers first? So they differ. No, pay me and I'll give it to you. No, give it to me and I'll pay you. And they're stuck. And in some cultures, it becomes a matter of honor. So there's a shari'i resolution to this as well, which is, of course, one is to have good character. And just, يعني, لا تنسوا الفضل بينكم, do not forget virtue amongst yourself, and to be the person who فاستبقوا الخيرات, go first. But people also see the ظلم of others. وفي بيع سلعة بثمن, in the exchange of a commodity for a price. سلم هو أولا, right? سلم هو أي المشتري أولا, right? In the sale of a commodity for a price, the price is paid first and then the commodity taken. Because the commodity, the item of sale is already specified. So you have to pay for it, then you take it. إن لم تكن مؤجلا, right? Unless it is deferred. وفي بيع سلعة بسلعة, in the exchange of one commodity for another, I sold you my sofa for 4 books. وفي بيع سلعة بسلعة أو ثمن بثمن, or in in one or for money, like a money exchange. سلما معا, they pay at the same time. They pay at the same time. So these are some associated issues. And next class, we're going to look, بإذن ta'ala, at an important investigation, which is options of cancellation and the like in sales. So I don't want to spend a lot of time on this. You can see it in the slides. We saw about sales with unit pricing and what is included and what isn't, what enters into a sale without mention, and what is excluded from a sale. and associated matters. Next, we are looking at, in lesson 4, on the option of cancellation, stipulating the option to cancel, its maximum duration, who owns what, in the meantime, while an option to exists. The option of cancellation is for, if it's stipulated that, okay, I bought a standing desk for my son, but I specify the option to cancel for 3 days. That is permitted in the Sharia. And we'll look at what's the difference between option of cancellation and a refund policy. A refund policy is different, but we're going to understand the two and related ruling. But also we're going to see the option of cancellation due to defect, due to mischaracterization, and other matters. So these options are ways, or the option of inspection. These are things that the Sharia gives the buyer or the seller the right to cancel if these contingencies arise. We ask Allah for subhanahu wa ta'ala for steadfastness and success. Wa sallallahu ala sayyidina wa nabiyina Muhammad wa ala alihi wa sahbihi wa sallam. The first part was more technical, right, of what happens if there's variance in the item of sale, etc., and the different measures, etc. We gave some diagramming to it that it helps to, please, once in your lifetime, diagram it yourself. It becomes conceptually very clear. Diagram the issues themselves and then put next to it the reasoning, which we explained in the class. You can find it, if you're able to access the Arabic, in the commentary. And then it'll be very clear. We shared in the class what are the principles. If you need to review the lesson, there's merit in reviewing it, but purposeful review, as mentioned. And we also took, very, very importantly, the principles of what should be clarified in transactions. So that حفظاً للتراضي. So we preserve this mutual agreement for all parties. وصلى الله على سيدنا محمد وعلى آله وصحبه